according to me, even that is a misconception. And there is a mandate of the law. That is, the enterprise value is going down. किया क्या है in your personal under the Insolvency and Bankruptcy Code?
Welcome to a BW Businessworld special, a BW Legal World special. In the last decade or so, the most important legislation and policy change that has come about has been the IBC. This year, the government has proposed amendments in the IBC. And to understand whether these amendments are right, what is going to be the impact of these amendments, are they being implemented well, what are the learnings of the decade of IBC, we have the Sachin Tendulkar, the Don Bradman of corporate law and legal, Dr. UK Chaudhary. So this is the inaugural episode of Understanding Corporate Law with the senior advocate, Dr. UK Chaudhary. It will be a fortnightly show. Every fortnight, you will understand the nuances of corporate law. How do they impact companies, entrepreneurs, capital providers, and all the stakeholders involved. So let me start by welcoming Dr. UK Chaudhary to Understanding Corporate Law with Dr. UK Chaudhary. Thank you, Dr. Chaudhary, for being here and talking to BW Legal World. Today we'll talk about something you know really well. Having practiced corporate law for a long time, having been involved in the IBC for the last decade or so, there have been amendments that have been announced, which will come into place soon. The IBC Amendments 2020-25. Tell us, are they a welcome step, or there's something that needs to be improved about these amendments?
Thank you, Dr. Batra, to invite me to this BW legal discussion. Your question relating to whether the IBC is a welcome step by way of an amendments, and whether it's a step in the right direction to implement the requirements of the Insolvency and Bankruptcy Code, which came into effect in 2016. The amendments have been proposed in this year, 2025. They are sent to the Select Committee. The Select Committee under Mr. Panda, an MP, have already prepared a report. The report has been submitted to the Government of India, and most probably in the next session of the Parliament, this amendment bill may be placed and it will become possibly the Act. Now, my take on the amendment is that as I see it, it's a kind of a mixed bag. There are certain amendments which are only, according to me, more clarificatory or providing a statutory backing to the decisions which already have been handed down by the tribunal, the appellate tribunal, and ultimately the Honorable Supreme Court of India. There are certain concepts which are completely new and they are being brought in for the first time. As and when we progress our discussion, I'll possibly give my personal take on whether those new concepts will trigger a tsunami of litigation, or whether they will be beneficial to the corporates or to even the banking institutions or the other financial institutions.
So, Dr. Chaudhary, let's directly dive into the biggest issue. The stated objective of one of the stated objectives of the IBC Amendment 2025 is to shorten the resolution process from a year to 6 months. And for that, an admission in 14 days, right?
Yes.
I would like your comment on that, because that's one of the substantial amendments that is being proposed.
Let me take this, that the 14 days concept is not coming for the first time. The 14 days admission of the petition as is filed before the Honorable National Company Law Tribunal was an original concept in the Act of 2016 itself, which was an IBC. That is Insolvency and Bankruptcy Code 2016. But as and when we progressed into the litigation, it was found out that the 14 days timeline was never possibly a practically acceptable to any tribunal.
And why do you say that, sir?
And that is how that it was treated as a directory provision by the Honorable Supreme Court of India eventually, rather than a mandatory 14 days.
Right.
Now that Honorable Supreme Court decision still stands and it's still a directory. What is being said in the amended bill is that if a petition is not admitted within 14 days from the date of filing, that it is taken up by the National Company Law Tribunal, then the person in charge of the tribunal at that time, that is the bench, will give a decision in writing that why it has not been accepted within 14 days. So the first part is whether it is fair on the part of the statutory body or the framers to lay down this kind of a condition that if a member is not able to decide the petition within a period of 14 days, then he will give a reason then why it is not done so. The second part is that is it at all practical
Sure.
to go? For that, one has to understand the nature of the litigation. Now, in our jurisprudence system, most of the litigations are the adversarial in nature. That there are 2 or 3 parties which are parties to the litigation. They have their own point of view, for or against. They have to be given a fair hearing. They have to be given a chance of saying their part of the averments or their acceptance or their rejection. And therefore, it's a long-standing process. That is the first part, which is procedural. The second is the judicial. That we always believe that nobody should be condemned unheard. So if you have to hear a person and then after hearing you have to give a decision, then whether it is a National Company Law Tribunal or whether it's a High Court or whether even the Honorable Supreme Court of India, it has to have a sufficient time at its disposal to reach that decision of an adversarial litigation by giving an equitable and fair chance of being heard before the tribunal. In that, looking from that perspective, I do not see that why it is being insisted again and again and again that the petition should be admitted in 14 days. Because it's not a question of yes or no. Yes. It's a question of deciding certain issued judicially and by giving a fair hearing to all persons concerned.
And just to kind of support what you are saying, we know that the average process has taken 700 days, right?
Yes.
Though it is specified 330 days, and some have taken up to 800, 850 days. So by the past experience, the past 9+ years, we know that this deadline is a little aggressive deadline, to put it mildly, right? Impractical possibly, right? And again, there is a view that the infrastructure to be able to decide this, both in terms of, the number of judges, the courtrooms, the support staff, is inadequate. I'm not even going in the quality of, resources. That is another aspect. What do you have to say on that?
Yes, Dr. Batra, I take it that this is my personal view from the very beginning, that number one, that this timeline is very impracticable. Nowhere in the world you expect any judicial body, and I'm saying it with a lot of experience, personal experience on my own profession.
You just completed 50 years in the profession in November.
Yes. So my personal experience in these 50 years has been that it is almost next to impossible if you have to have a judicial decision with fairness and granting a time which is adequate for the purposes of any adversarial litigation to be decided. So it is very, very, very difficult to reach this kind of a deadline, and I have not seen that anywhere in the world, except by way of an administrative process, that you can say yes or no to a given proposition of law. Now, even in our own IBC, if we see the whole concept, the concept is based upon determining that whether there is a default in repaying the debts, or in the first place, is there a debt in existence at all? Now, both the proposition of law requires a determination. Determination means a judicial process. A judicial process means a fair hearing. A fair hearing means a reasonable time to be granted to the parties to prepare and advance their arguments for or against. Now, this whole process takes time. Now, in this whole process, the first part is the judicial process itself takes more than certainly 14 days, according to me, more than 6 months. So by now, with our experience of 9 years implementation of the IBC, would have been more practical in this timeline. Instead of, I was hoping that instead of 14 days, they will say that the petition should be decided within a period of 6 months. To my surprise, I find out that not only that the Honorable Supreme Court's decision that 14 days, 30 days, 330 days, all are not mandatory but directory in nature. Now, keeping on that, then to put up an obligation on a member of the NCLT to say that why the petition was not decided is, according to me, very, very unfair.
And why do you say that? Because these are matters of technical examination, of detailed examination, of understanding the nuances in terms of debt, in terms of creditors, so on and so forth. And also the concern is an ongoing concern, right?
Yes.
So what is the point in hurrying it? I mean, of course, you want to resolve it faster for all positive reasons, but why this hurry?
I myself not able to understand that why so much of impatience is being shown. According to me, that anything done hurriedly means that it has been buried.
Yeah, justice hurried is justice buried.
If it is so, then according to me, we have to be more practical in the timeline. I will, if personally somebody has to ask me to legislate, I will say give 6 months time for the admission of the petition, which in any case is taking time. I have not seen any petition being admitted, what about 14 days, even in 140 days. My personal experience as a person who is going 4 times a day to the NCLT and to the Appellate Authority and to the Supreme Court of India, I have never seen any litigation coming to an end in 14 days. So I do not see that under the pretext of saying that the delays must be cut, that how much you can cut the delays. Every person is saying that we should cut the delays because the companies, that is the enterprise value, is going down. According to me, even that is a misconception. Most of the corporate debtors which are being taken to the NCLT under the Insolvency and Bankruptcy Code are not the closed undertakings. They are the working enterprises. And there is a mandate of the law that even after the appointment of the interim resolution professional, IRP, or even the resolution professional who becomes the RP later on, even there is a law mandates that it will be kept as a going concern.
Right.
So if it is a going concern, where is the loss of enterprise value? I don't understand. The enterprise value possibly can only go down if the CIRP fails and a liquidation order is passed. But there is a mandate even for that even during the liquidation also, there is a mandate that it can be sold as a going concern or it can be sold as a closed enterprises, that is in piecemeal, asset by asset. Therefore, I'm not able to, frankly speaking, I'm not as a professional, I'm not able to understand that where from this concept is coming, that everything must be decided within 14 days, within 30 days, within 7 days, within 140 days, within 150 days. It is an adversarial litigation. It requires to be closed with fairness, equity, and judiciousness.
And we've seen over the last 9+ years that it does take time, right? So
it has always taken time.
We should have learned from it and put a more practical time frame.
Exactly. So I am not understanding that where from this timeline is being asserted again and again and again, and why.
Okay, Dr. Chaudhary, you said it in a Businessworld interview 3 years back that the capacity building of the whole system needs to be better. right? Both in terms of judges, both in terms of infrastructure, support staff. And I will come to the kind of people because, we'll talk about our, but tell us what is the kind of infrastructure needed to be able to solve the pendency of cases, right? Currently, more than 30,000 cases are pending. About 7,000 cases are being examined to be admitted or not. So give us a sense of what is the kind of infrastructure needed. Then we'll come to the skills and competence in a while.
Okay, I think this is a question which is very close to my heart, and at number of forums I have been able to express myself without any inhibition that this is the one issue which sometimes doesn't let me sleep in the night. And it is so close to my heart that as a member of the Bar Association and also as a professional who spends almost 70% of my times before the National Company Law Tribunal and its appellate authority, I can say with certainty that the infrastructure has not kept pace with the requirement of this so-called time deadline. Let me start that we have, as of now, 28 operating benches in the National Company Law Tribunal. We have 9 members in the appellate authority with 4 benches working. 4 in Delhi and possibly 1 in Chennai, which is a only bench outside Delhi of the appellate authority. We have 6 benches in Delhi of NCLT. We have equal number in Mumbai, and at most of the capital cities, we have 1 bench or the 2 benches. Now, if we take that we have 28 benches, the infrastructure is completely inadequate. I have yet to see, again and again recommended by the Honorable Supreme Court of India in the 2 decided cases, one in 2010, another decided in 2014. In both the cases, it has been affirmed by the Honorable Supreme Court by a judicial precedent that the status of the National Company Law Tribunal must be not less than the high courts in India. But looking at the infrastructure, forget about the high court. They do not have the infrastructure or even of a district court. In Delhi, where I practice most of the time, I find out that out of the 6 benches, the 2 benches don't even have the courtroom to sit. We created a courtroom in some other building, and till today, we have not been able to decide the entry of the lawyers and the members in that courtrooms because somebody is objecting in that building that lawyers cannot go in that building. And this is the kind of an attitude that the government is taken towards the tribunal. And I'm sorry to say this, that this is a completely uncalled for situation. We should have a better infrastructure. We conceived under the Companies Act that we will have 63 members just to deal with the litigation arising out of the Companies Act 2013. Then we have an added institutions like the Insolvency and Bankruptcy Code and its number of cases, which are at least in number 10 times more than the company cases. But our members still are less than 63. So looking at that, other than we don't have the adequate courtrooms, we do not have the infrastructure, we do not have the members, we do not have the supporting staff. I have been reported that number of benches don't even have a good stenographers to dictate their judgments. If this is the kind of situation, I do not know that under what compulsion you can again and again say, no, everything must be decided in 14 days or everything must be done in 30 days. I think it's completely impracticable, and something is working somewhere which have no foggiest idea that how the courts work.
Clearly, you make a very compelling argument based on your experience, given your extensive experience in this domain and your passion for solving this for a larger good. Now, let me focus on qualitative aspects. let's focus on the constitution of the NCLT, right? The members. There is a certain kind of members being made, right? And in the past, there are various professionals who said that it is a good start by bringing them on. But as this process becomes more nuanced, technical, different kind of members should be brought in. What is your view on that?
It's very unfair on my part to comment on the qualifications or the skills of the members. As a professional who appears before the tribunal every day. But if I go by the intent of the parliament and the legislation, it was provided in the legislation itself that there will be the professionals who will be the technical members, like the lawyers, the chartered accountants, and the company secretaries. The company secretaries and chartered accountants and other professionals will make a technical member. The lawyers and the persons from the judicial services will make a judicial member. Now, looking from that point of view, I have not seen that in the last 10 years, ever, the company secretaries and the chartered accountants have become a majority of the technical members. Majority of the technical members still remains the persons who have retired from the various government services. And the size of the company secretaries, the chartered accountants, members of the Institute of Cost and Works Management, and other qualified people like the management experts, etc. They were supposed to be the expert on the company law and expert on the insolvency and bankruptcy code when it came, even if thinking that it's a new legislation. This has not happened. The percentage is not more than 5% of the professions are taken. The 95% comes from the retired government bureaucrats. Same is true that not many people who are qualified to be the High Court judges will become the judicial members in the National Company Law Tribunal. Even that requirement has not been met. And this is not what I am saying from my personal experience. This is what mandated in the Companies Act, and this is what is mandated by the two judgments of the Honorable Supreme Court, one given in 2010 and another given in 2014, known as the Bar Association of Madras High Court versus the Union of India. Anybody, these are the judgments available to any person available on site. Anybody can look at them, that what are the qualifications prescribed for the members. I can only say that our expectations have not been met by meeting those requirements which is provided by the statute and which is provided by the judgments of the Honorable Supreme Court.
Okay, fair enough. I think it's a fair comment. And you say it for improving the quality of decision making and more nuanced decision making. Now let me come to the quality of IRPs and RPs. Again, there are more than 70 disciplinary proceedings against RPs and IRPs which have happened in the last few years. Again, there is a belief that more lawyers and accountants are becoming RPs, but people who understand how companies work, technical experts, technocrats, are not becoming RPs. What is your view on that?
It's Dr. Batra, it's a very good question. And this was the concern which was flagged right in the beginning in 2016, that the insolvency professions will be the one which will be registered with the insolvency professional institutes. Now these two institutes have been created as a special body by the Institute of Company Secretaries of India, by the Institute of Chartered Accountants, and the Institute of Cost and Management Institute. All of them have their 3 IRP institutes, and all of them have their registered members. Now the qualification to begin with was the acceptable qualification as a lawyer, as a chartered accountant, as the Cost and Works Management Institute member. But I have not seen any other good professional coming. Like, I don't understand that why certain people who are already working with the trade and industry, the people who are the members of the trade bodies like the PhD Chamber of Commerce, CII, or FICCI, for that purposes, these are the bodies who have lot of expert who deal with the trade and industries. So why they have not been roped in to become the insolvency professionals? After all, it's not a kind of profession which is not paid well. They are paid so well that, in fact, in my information, that 4 or 5 big financial consultants like the PwC and KPMG and E&Y, they have separate division in which they have taken something like about 50 to 60 IRPs. And they are the people who the banks are picking up from to become ultimately. So this kind of capturing the institutions of the insolvency professionals have become a part of a game plan. That here is a person who becomes in charge of the company. If you have in control of that person, you are in control of the body corporate. And if you are in control of the body corporate, then in the control of the affairs for a period of 1 year or 2 years or 3 years until the CIRP is over. And thereafter, if not that person, some person connected with them become the liquidator. So then you can control further that how the assets of that corporate will be liquidated. Now, this has become a game plan which is not to my liking, frankly. There has to be done something must be done by a body like IBBI to look for the honesty and integrity of these persons. So qualification is one part, but human character is another part. Do they possess a good character also along with a good qualification? And that is one thing which is lacking in all the professionals. Whether that is lawyer, whether that is chartered, everybody is emphasizing on the qualification and the skills and knowledge. Nobody has ever said that along with this, what is the most important for a human being is to possess a good character.
Integrity.
Integrity.
Good intent. It's a very important, given that more than 70 RPs have disciplinary proceedings against them. The point you're making is absolutely needed. Now, let me dive into another aspect. While you said that there is an RP which is appointed, and so the stated objective of the the whole process is that the company should be a going concern. It stays a going concern. The running of the company is not disrupted so that the value is restored. But let me make a distinction between manufacturing company or a company that has assets versus a services company where the assets are people and processes and the brand. And the moment something like this happens, it impacts that. So should there be a distinction between the IBC process for a manufacturing company and say a financial services company? Because in the last 3 years, I have seen instances where this issue has been debated.
Yes, but as you know that the financial service companies or the securities providing companies are not within the ambit of the IBC. There are certain kind of service providing companies which form part of the IBC clan, manufacturing companies. But in both cases, I can never think that there could be a devaluation. If there are the assets start devaluing only after the CIRP process has stopped or come to an end, one way or the other. If it is successful, that in any case goes as a manufacturing concern. And therefore, it is taken over by another successful resolution applicant. If it comes to an end, that in any case, they go into the liquidation, and in the liquidation also it can go as a going concern, or it can go piece by piece, that is asset by asset. So in both cases, this concept and saying that with the delay, there is a vast devaluation in the assets of the company. According to me, this is a complete misconception. Somebody is playing the trick somewhere just to expedite the process and to sacrifice the judicial process. This is a bogey being created. I do not see any devaluation because I see that there is a mandate by the IBC code itself, that the code itself provides that as far as possible, even under the IRP or the RP, the company will be kept as a going concern. And then there is a COC to look after the interest. That is the committee of creditors. Now, committee of the creditors, the bankers or the financial companies or the ARCs, why they will let the company be devalued during the process of the CIRP? They have everything within their power and reach to keep this as a going concern.
One of the things is, as you said right at the start, is that because of the learnings of last 9+ years, there have been judicial pronouncements, there have been precedences which have now being moved into statutory provisions, right?
Yes.
Now, one of them is about government dues, right? Yes. Give us some insights on that.
The number of judgments of the appellate tribunal as well as the Honorable Supreme Court, it is already a settled law that the government dues are not the secured dues. But there are 1 or 2 cases where the statute provides for creating a lien on the assets of the user of the services of the government, like the electricity or like the water supply. So or like the sale tax or like the income tax. So there are certain statute which provides for creation of a lien on the assets of the company. Now, there are some more judgments that where there is such a creation, then the government dues will be considered as a secured creditor. Now, even present amendment has done with that also by creating a definition that what is a security interest, which cannot be created by the statute, which has to be created only by way of an express agreement between the company and the service providers. Now, therefore, that has been now put into the statute, that what is being stated by the courts is now become a part of the statute. Similarly, there are number of amendments which are, like said, the clarificatory in nature, because the judicial pronounce has already been like a clean slate concept, where the Supreme Court, in a case like the G.K. Mishra case, has already said that once the CIRP is over, then thereafter there cannot be any question of recovering dues from the corporate debtor by any person. The balance sheet will become clean, whether you agree with it or not, within the concept of the Companies Act. But this is a stated position of law that it is settled, and it is beyond any doubt now that the Honorable Supreme Court has laid down the law that once a CIRP is over, then the balance sheet of that company will become completely clean, that is without any debtors, or it will become a zero debt company. Now, this position may not be suitable to many other stakeholders. For example, it's highly detrimental position for the operational creditors, who are mostly the small dealers or the small companies. SMEs. Now, if these small companies or medium scale companies, their debts are also converted into zero debt, it means that they are the companies which are heading for a financial distress without any fault of theirs. But this was already a settled position. This position has not changed. But there are certain concepts like this which have now become statutory. But when I deal with this position little later, but there are some new concept which is a fundamental change in the IBC. For example, that there is a new chapter being added. That new chapter is starting from section 58A and it goes right up to 58K or L. Now, if we look from those sections, there is a new concept coming, and that new concept is known as the Creditors-initiated insolvency corporate process. Now, if that resolution process comes into without even filing a petition before the NCLT, then according to me, it's a complete sacrifice of the judicial process.
Absolutely.
And in my personal opinion, I don't vouch for others, but in my personal opinion, it will open up a Pandora's box for litigation. It's a floodgate. You are inviting litigations unnecessarily. Because the moment a financial institution, that is like a bank, decided to start this creditors initiative resolution process, it means that on his own, this one bank can decide, go to the other banks in the same category of the financial credit, and then take a 51% consent and appoint a resolution professional. The resolution professional then gives an advertisement, public advertisement. The process is put into motion. The only saving grace is that, like a admission of the petition under section 7, 9 and 10, the board gets dysfunctional immediately. Here at least the board of directors remain in charge. But then there are more provisions which will invite. For example, there is a now new section which has been put in, that the resolution professional who is appointed with the consent of 51% of the same category of the financial creditors, once he comes into place, he will attend all meeting of the board of directors and he will attend all the meeting of the shareholders. And he has been given a veto power, that any decision taken by 100% of the board members, 100% of the shareholders, can't even be binding on enforce if this person says no. Now, according to me, a provision like this will certainly...
It is counterproductive.
Yes, it's counterproductive, open up a floodgates for litigation. Why any promoter will let such a person, and why the 100% of the shareholders or 100% of the board have to be overridden by a judicial process, which have not been provided anywhere in any other law except the Insolvency and Bankruptcy Code.
So then let me ask you, what are the positive steps in this IBC Amendment 2025?
See, according to me, except that this is more of a clarificatory in nature and a new concept are being pushed.
Which have been learned in the last 9 years.
Which possibly, because to cut delay, they want now the creditors initiative to start the resolution process. Now, according to me, it's counterproductive in the sense that not that it becomes final on its own. Ultimately, even this process is challengeable by an application by a promoter or by a board of directors or by the company itself by making an application. And then there is another process inbuilt, that if this process fails, then the NCLT itself can convert this process into a regular process of the resolution process under Chapter 2.
Back to square one.
So you are back to square one.
Right. So clearly, I think while the IBC Amendments 2025 are welcome, clearly some of the suggested amendments don't seem to be in unison with the natural justice process. And thank you for raising those. And as we end the first segment today of Understanding Corporate Law with Dr. UK Chaudhary, what would be your final comment?
My final comment is that I wish that the select committee of the Parliament, which has been given the task of finalizing this bill, should have consulted little better known insolvency or domain lawyers, who could have told them that what actually happens in a court of law. To be theoretical is one part. To be practical, looking at the process of law, is a different part. You have to be more practical to blend both the processes, the process of the statute and the process of the court. Unless both are blended into unison, you can't achieve the positive results.
Beautiful. Thank you, Dr. Chaudhary. This was the first episode of Understanding Corporate Law with Dr. UK Chaudhary. We'll be back with the second episode soon. Understanding Corporate and Business Law with Dr. UK Chaudhary. We'll focus on some other aspects of the Insolvency and Bankruptcy Code. And I'm sure you'll take away some things that will help you understand the nuances. Thank you, Dr. Chaudhary.
Thank you, Dr. Batra.